Good morning. My name is Deborah Weissman. I teach law at the University of North Carolina School of Law at Chapel Hill. And I want to thank Representatives Insco, Harris, and Black Montgomery, the primary sponsors, for this very important bill, which I believe starts to bring us in line with our international legal obligations, both as a state and its political subdivisions and private actors. So what are the state's obligations to survivors of extraordinary rendition and torture that resulted due to the CIA torture program? Our obligation is clear, according to law, at all levels, starting at the international level. International legal obligations include the prohibition on torture, requires the accountability and investigation when there are credible allegations of torture, and it also requires reparations to the survivors and their families. We have heard time and again from state and local officials that the enforcement of international law doesn't fall within their province, but that rather it's a matter for the federal government, but that is an inaccurate statement of the law. There are fundamental principles of international law that require no treaty, no statute, no formal enactment, and those we call jus cogens, or relatedly customary international law, and they pertain to acts that we as a civilized world have decided are so egregious that they cannot be enacted anywhere. Torture is among those types of legal norms. There does not need to be any sort of treaty, and our courts have said as much. Our courts have said there is no dissent that customary international law, such as found in the UN Charter or the UN Declaration of Human Rights, which we have said is customary international law, prohibiting torture is binding on all of us everywhere and at any time. We have also enacted treaties. We have signed and ratified the International Convention on Civil and Political Rights and the Convention Against Torture, both of which prohibit torture under any circumstances. There can be no justification for torture. And when we ratify these treaties, it means that they are applicable to all levels of government. So let me just read you from our Supremacy Clause in our own Constitution, our federal Constitution. It could not be more clear, and it states, "This Constitution and the laws of the United States shall be made pursuant thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding." And at the time of ratification, the Senate said, we don't really need to enact any kind of significant federal legislation because torture is already prosecutable in every jurisdiction within the United States. We've enacted federal laws to assure compliance with treaty requirements. Nonetheless, the Federal Torture Act of 1994 was brought into reality to make sure that the United States was in full compliance with our obligation not to torture. So we have not complied with these obligations, but this bill really goes a long way to assure that we can do so now. It aligns the state with regard to definitions and obligations that match up with our international obligations. It begins the process by which our state can acknowledge that events of rendition, disappearance, torture took place, and make transparent the human rights violations that individuals have suffered. The bill's requirement that airports adopt policies that would prohibit participation by any airport tenants or aviation users is critical, again, to lining up with our international obligations. And so I hope that this bill goes where it needs to be, which is passage, because we will then be able to raise our heads as good international human rights citizens. Thank you.